Can I create a trust just by saying that I created a trust? Hi, everyone. My name is Leah Boston. I'm an estate planning attorney here in the state of Maryland and owner of Law Office of Leah Boston, LLC. I draft wills, trusts, and I talk about long-term life care planning with people like you. You may be wondering why this video looks a little bit different today. It's actually because I'm under the weather, but I still wanted to push out some content, so I figured this would be a better background to view than a sickly, ill Leah. Well, I'm not that sick and I'm not that ill, but it's not a pretty sight. Bonus, I actually ordered some microphones and I wanted to test them out. So I figured this would be kind of like a really good round to check and see the, efficiency and how good these microphones are. So I guess this is kind of like a podcasty sort of video today, as opposed to my normal ones where you can, see me. So back to the question, can I create a trust just by saying that I have a trust? So this would be an oral trust. Well, here in the state of Maryland, a trust doesn't actually have to be in writing to be valid if the creation and terms of the trust are established by clear and convincing evidence. So now when we say clear and convincing evidence, this is actually a standard, an evidence standard, like a standard of proof that you have to meet in order to say, that this is what it is. And I will say, creating a trust orally and having to meet the clear and convincing standard, it's almost impossible to meet this standard. So I would say, although a trust can be valid if you say that you have created orally, the standard of proof that you have to meet just to show that this trust is what it is almost impossible to meet. Therefore, it is recommended that you create your trust in writing. And so Maryland actually kind of goes by the execution requirements of a will. Although there's no particular execution requirements for a trust, it's standard for estate planning attorneys in the state of Maryland to follow the creation of a will the same way that they would create a trust. Usually this is in writing and then it's signed by the testator. This is the person that is creating it, or it's signed by a person on behalf of the testator with the testator's permission while in the testator's presence. I know that's a mouthful, but follow me here. So say, for example, the testator is blind or the testator is, infirm and unable to, actually write the signature. If someone is in the room with them and the testator has expressly stated, or they've, shown enough evidence to show, I want this person to sign on my behalf, that means that that person that is essentially next to the testator, or at least within close proximity to the testator, can sign on their behalf. And then usually it's attested and signed by 2 or more witnesses that are also in the presence of a testator. And I do want to note something, that most trusts will hold real property. So if you want to go the route of having a trust that is created orally, you cannot hold real property in there. So if you do have a trust and you know that that trust is going to own real property at some point in time, that trust needs to be in writing. Just because statute of frauds issues, etc., that we lawyers learn in law school that I won't dive into here, anything that is holding real property, it has to be in writing and signed by the parties and the person that is legally able to create the trust, or else the trust is void. So back to the question, can I say that I have a trust just because I have literally said I have a trust? Yes and no. Yes, if you plan on trying to meet that burden of proof of clear and convincing evidence standard, which is, like I said, almost impossible to meet. No, if you plan on having the trust own real property or any sort of real estate that you have. I hope this was helpful. I also hope that this was educational. If you would like to get started on your estate planning, if you would like to get started creating your trust, especially because you know that it's going to hold real property, particularly if you're in the state of Maryland, please do not hesitate to contact my office at www.leahbostonlaw.com, and I'm happy to help get you started. Otherwise, if you have any questions, please leave a comment below, and I'll see you in the next video. Bye.